Okay, good afternoon, everyone, and welcome to the Soapbox panel. Sorry about the slight delay. We're waiting for the human rights lawyers to get here. So, what an exciting day. Well done, everyone. This has been really, really interesting. I've been to 3 panels, and they've all been immensely interesting. Nothing for you guys to live up to now at all. The standard has been set. So, this is the Soapbox panel. That means that our 4 speakers up here have agreed to get up on the soapbox and express their usually political views, if I understand soapbox correctly, to express their views on their chosen topic. Those topics, we have Ben Murphy first, who's speaking about the Security Council, saying that it's unbound by law. Alex Kaiserman speaking about partial liability. Seamus Byrne arguing whether or not children should have the right to vote. And Joshua Hughes speaking about killer nerds, the legal problems with the NSA's role in targeted killing. We're going to get started with Ben Murphy. You have 5 minutes on the dot, as you'll see. When your 5-minute ends, we have 10 minutes to give him a good old grilling. So Ben, if you want to come up here, I'll start as soon as you start speaking. Where is it? Yeah. I forgot to introduce myself, by the way. Sorry, my name is Michelle Farrell. I'm a member of staff here. I'm a human rights lawyer, and I have no idea why I've been chosen to preside over this one, because I'm certainly not an expert on soap. I'm not sure. Okay. Oh, this is annoying. You can start.
Okay, so the topic of my presentation is one of the oldest questions in sort of legal and political thought. Is there any limit to power? Even the thinnest understanding of the rule of law would suggest that any discretionary power should not be absolute. Anyone, even those who make or enforce the law, should still be subject to that law. On the contrary, I was told to make a controversial argument. My controversial argument is that the most powerful institution in the world is in no way subject to international law in the exercise of its powers. Before we get there, let's say, what can the Security Council do then that is not bound by law? Article 24, UN Charter, the Security Council's primary responsibility for maintenance international peace and security. In order to fulfill that role, the Security Council has a number of enforcement measures it can impose, from economic sanctions all the way up to the authorisation of military force. The Security Council is the only institution that can authorise use of force, which just shows quite how powerful it can be. Commentators would suggest that discretionary power being unlimited is so unthinkable, intolerable, that people are very helpful to us and they tell us all these legal limitations that the Council may have. 5 minutes, 5 legal limitations. Commentators would suggest that they all limit the Charter. I'm going to say that none of them do. If 5 people in the room accept that I'm right about one of them, then I've won. There's no legal limitations on the Security Council. So the first place to look, we start with 24, we'll stay with 24. The first one is Article 24.2. Implies that the Security Council is bound by the purposes and principles of the UN Charter. The purposes of the UN Charter are thus. In red, these are the enforcement measures. We see here effective collective measures. But the red part is in no way qualified by the following statements. The qualification is in conformity with the principles of justice and international law. The part that's qualified is the black part. Adjustment or settlement of international disputes. That's Chapter 6. That's got nothing to do with enforcement measures. So the implication is that whilst the counter-argument in Chapter 7, they don't need to worry about silly things like justice and international law. They can just do whatever they want. Article 2.7, the domestic jurisdiction principle. No one can intervene in matters that are essentially in the domestic jurisdiction of the state. Look at the bolded part, that doesn't apply when talking about Chapter 7 measures, need I say more. Article 39, so the bolded part would be that the Security Council shall determine that there is an existence of a threat to the peace. I accept this is a limitation, but it's only a procedural limitation. If an adequate number of states on the Security Council want to pass the resolution, then they just have to put a little line in the resolution that says that it's a threat to the peace. It's not a substantive limitation, because nowhere is a threat to the peace, breach of peace, or active aggression defined. And we know that this is essentially just a political discretion, political decision that the Council has absolute discretion. We know this because the Security Council is quite happy to take action in civil conflict. So we know that isn't a threat to international peace at all. So they redefine the meaning of a threat to the peace, all the way to the extent that apparently climate change constitutes a threat to the peace. But up until very recently, the situation in Syria didn't constitute a threat to the peace. So we know that this is a political decision. It's not governed by any substantive content. We move to the actual enforcement measures then, Articles 41 and 42. Article 42, there's potentially two limitations. The Security Council first has to decide that Article 41 measures, so measures up to but not including use of force, are inadequate. Again, it's a limitation, but it's a procedural one. The Security Council would just say it's our role to maintain international peace and security. Have a little think about this behind closed doors, and measures not including use of force will be inadequate in this situation. So we're going to go to Article 42. They haven't had to pass a resolution previously under Article 41 again with those measures. The big one then is this final bolded part, as may be necessary. This implies a proportionality requirement as to what the Security Council must do. But if we go all the way back to the purposes of the UN Charter, the main purposes of the UN Charter is to maintain international peace and security. The rest of it is and to that end. So everything else is after the maintenance of international peace and security. There's nothing higher than the maintenance of international peace and security. The Security Council just say what we're doing is to maintain international peace and security. What is disproportionate to the maintenance of international peace and security? The preamble of the UN Charter says that the main idea behind the UN Charter is to save succeeding generations from war. If that's what the Security Council wants to do, then what can be disproportionate? And finally, in relation to proportionality, proportionality requirement doesn't say anything about the legality of Security Council conduct anywhere, because disproportionate ends can be, illegal ends can be proportionate to an illegal policy, because there's nothing about legality. Also, Security Council resolutions are binding. So the bolded part would suggest that only resolutions that are passed in accordance with the present charter are binding on the Security Council. It's not. Please.
Excellent. Thank you, Ben. I don't know where you're going because you now have to endure a 10-minute grilling. Is everyone convinced that Ben Murphy is right, that the Security Council is unbound by law? I know I'm not. My question for you, Ben, to get started on the grilling is I'm not convinced because I think you've got a problem with your title. The Security Council is the law.
The Security Council is the law to the extent that it's a law unto itself. But for the Security Council to be bound by its own law, it would have to accept its own precedent. The Security Council continuously redefines its precedent, ignores it on a whim, and brings back to life resolutions from some 50 years ago, if that's the decision of the day.
Good. Who's next? Grill Ben.
Someone get there before Patrick.
I'm going to start identifying people to grill on, so somebody raise their hand quickly. Thank you.
What bounds are you in? United Nations Security Council. What bound? Why is it? Why people are coming together?
Okay, yeah. So there absolutely are limitations on what the Security Council can do, but I would suggest that these are political limitations. I think there is potentially an illustrative analogy with the sovereignty of Parliament in the UK. Just for my the UK Parliament is sovereign. It's not bound by it can make or make any other bonds, but it doesn't. When we used the blue-eyed baby analogy, Parliament could pass a law that bans blue-eyed babies, but it doesn't because there are political repercussions. And this is even more when this is heightened even further when we talk about the UN Security Council, because member states complying with their resolutions is absolutely a necessity for the effective function of the UN collective security regime. So the Security Council know that they need states to follow their resolutions, they need states to comply. So they need to pass resolutions that are legitimate. But I don't think it's necessarily international law that regulates this, because there's just no consistency.
Come on, Mike.
I think everything he says is correct.
Always.
What's the defense?
Mike.
So what about, you talked about this kind of distinction between political constraints and international law, but I wonder whether when we get to the kind of amorphous nature of international law, whether that distinction actually is an illegitimate one in order to serve your argument. And actually, if we take a jurisprudential approach and view international law and the Security Council as some embodiment of international law as being the creation some kind of social contract of states. And in that case, it's the creation of law. It's bound by that social contract of states. It can be revoked at any time. Therefore, it's bound by law in a sense.
I really just realised that I don't need to talk as quickly as I did when I was talking for I've been like rushing through the answers as well. Yeah, I think you make a really good point. And in this distinction I was making between the political and the legal, I was only really referring to the definition of what constitutes a threat to the peace. Because this Article 39, this determination of what constitutes a threat to the peace, is only really a gateway provision into the enforcement measures. It's a procedural political check that they have to go through. Going any further than that and saying that, oh, the Security Council is not bound by law because everything it does is political, well, yeah, that doesn't get us anywhere, because whilst it's a very political institution, the Security Council has the power essentially to make law. But more than that, there is this social contract element whereby states have voluntarily given up some of their sovereignty in order for the Security Council to fulfil their collective security requirements. And we see that in Article 24. Did I have 24? The members confer on the Security Council this power. They voluntarily give up that power. And there is an argument that suggests that the Security Council is made up of individual states. So states are limited by international law. Clearly, states are subject of international to international law. They have international responsibility, so the Security Council can't just take on powers that states wouldn't have in and of themselves. And my response to that is, well, they can, and it does, because the Security Council has powers that states individually do not have on their own. And I think the nature of these powers means that they are not subject to any legal restraints whatsoever. And we see that in the fact that there's no court of law that has jurisdiction to pass judgments on Security Council resolutions. The only court that would have that jurisdiction is the ICJ. They expressly do not have the power to review Security Council resolutions. This was debated extensively in the drafting of the Charter. And even whilst they've been given opportunities to do so in the subsequent case law, the ICJ has not taken on that role. And we've seen in this sort of comparative, domestic constitutional law perspective, that more often than not, states are not given that role in the constitution, they just take it on themselves. But the ICJ has not taken on that role, and obviously regional and domestic courts do not have jurisdiction to review Security Council decisions either. So that would be my response.
I think you just got another soapbox there, Ben. Magic.
Yeah, so you mentioned the purposes of the Charter, and I agree with you that it indicates that the Security Council doesn't have to abide by international law when it uses its enforcement powers. But during the drafting of the Charter, they said the minimum standards have to be the principles of the UN Charter, and that includes principles such as state sovereignty, okay, it's limited by the Charter, and territorial integrity. So would you say that, say, the Security Council is able to annex a state's territory, or do you think that the purposes or the principles of the Charter actually limit it in that sense, and then it's bound by law?
The former. I think that the Security Council, whilst taking enforcement measures under Article 42, therefore violates the state sovereignty and territorial integrity of that state. And I know that's taken quite a broad understanding of what territorial integrity might mean, and others would take a more restrictionist understanding of territorial integrity, and they would suggest that it does mean exactly that, the annexing of territory. But just because the Security Council has never annexed territory, it doesn't mean that it can't, and it doesn't mean that there's a legal limit, there's a legal obligation for it not to do so. 25 years ago, we would have thought it would be unheard of for the Security Council to establish a criminal tribunal in the way that they have in Yugoslavia and Rwanda. 25 years ago, it would be difficult to square the maintenance of international peace and security with the establishment of international criminal tribunals. 25 years ago, we would have deemed it very strange and surprising for the Security Council to deem climate change as a threat to international peace and security. If you accept any of my arguments that these legal limitations are either very weak or not there, then I don't see any reason why the Security Council couldn't annex territory if it was proportionate to the maintenance of international peace and security.
I think we have time for one more. Let's go, Amina.
What's the solution?
The solution is me sort of probably getting off my platform before and stop playing sort of like devil's advocate and admit that I think that a lot of these legal limitations are actually a little bit stronger. So maybe bring to light some of the things that Patrick wants us to talk about. But more importantly, my actual answer would be more politics. It's a political institution. It's a deliberative body. More politics in the open. Less deliberation behind closed doors and the public proceedings where individuals in the Security Council will just sit there and read their statements. Let's deliberate in public. Let's have more democracy at the highest level of international politics. The answer is most definitely not a sort of power to review from the ICJ. The answer is more politics.
Any final burning points? Questions? Excellent. Ben Murphy, I think you just wrapped that up in the manner of a Greek Socratic scholar. More democracy, more talking. Brilliant. Great start to the soapbox. Up next, and I'm going to have to fidget here for a moment with the clock thing, but up next. Claire, thank you. Oh, hello. Up next, we have Alex Kaiserman from the University of Oxford, and you have 5 minutes, starting from now, to speak about partial liability.
Okay, so in most cases, liability in tort law is all or nothing. A defendant is either fully liable or not at all liable for a claimant's losses. What I'm going to try and convince you of is that the law should recognize the possibility of partial liability. In particular, I'm going to argue that a defendant should only be held liable for a loss to the degree to which the defendant's wrongdoing contributed to the causing of the loss. Now, a lot of legal commentators have expressed a bit of skepticism about sort of degrees of causal contribution in the law, but they needn't be skeptical, I think. To see this, consider the relation of authoring. Authoring is all or nothing, so you either author a book or you don't, there's nothing in between. But that's perfectly consistent with the possibility of multiple authors contributing to the authoring of a book to different extents. Same is true of causation, I think. So causing is all or nothing, an event either caused an effect or it didn't, nothing in between. That's perfectly consistent with the possibility of multiple causes contributing to the causing of an effect to different extents. And once we realize this, I think we can start to resolve a number of conceptual difficulties in tort law. So take, for example, the concept of proximate causation. So most jurisdictions have a version of this doctrine whereby a defendant can only be held liable for a loss if their wrongdoing was not merely a cause, but also a proximate cause of the loss. And the dominant view in the literature seems to be that proximate causation has nothing to do with causation, because once you've established that the wrongdoing was the cause of the harm, then that exhausts the causal inquiry. You're done. You've already answered all the causal questions it makes sense to ask. But I think that's wrong. I think once you've established that the wrongdoing was the cause of the harm, then there's this further question, the question of the degree of contribution that the wrongdoing made to the causing of the harm. And so, given this, I think a natural interpretation of proximate causation suggests itself. A proximate cause of an effect is an event which contributed to the causing of the effect to a significant degree. So interpreted proximate causation doctrines impose a threshold on the degree of contribution of the defendant's wrongdoing to the causing of the harm, above which the defendant is fully liable for losses, and below which the defendant is not at all liable for losses. So what I'm saying is we should just replace this all or nothing approach with a sliding scale. So when a defendant's wrongdoing was one of a plurality of events that collectively caused the harm, the contribution the defendant should be expected to make towards repairing that harm should be equal to the contribution the defendant made towards bringing that harm about. So this is a principle I call proportionality. And there's one big objection to proportionality, which is that it's much too biased in favor of defendants. So to illustrate this, suppose Big Corp and Little Corp both release toxic substances into a river, and that collectively causes damage to Greta's property. And Big Corp, let's suppose, contributes to degree 0.6 to the causing of the damage, and Little Corp to degree 0.4. But Little Corp, let's suppose, is insolvent, so it's not able to discharge its 40% liability for Greta's losses. Now, under the common law system of joint and several liability, Greta could still sue Big Corp for 100% of her losses. But under proportionality, what I'm suggesting, she'd only be able to sue Big Corp for 60% of her losses, and she'd have to absorb the remaining 40% herself. And this seems unfair to many people. Why? Well, because Greta's this poor innocent victim, and Big Corp is this negligent multinational corporation for whom 40% of Greta's losses is mere small change. Why shouldn't it absorb the losses? So what I want to suggest is that this objection rests on a failure to distinguish between two different kinds of justice: distributive justice and corrective justice. So everyone is agreed, I take it, that if the damage to Greta's property arose through natural causes, then Greta would have no claim against Big Corp because its activities, however negligent, didn't cause Greta's harm. Greta wasn't wronged by Big Corp. The duty to compensate Greta in this case would lie not with Big Corp, but rather with the state, or failing that, Greta's community at large. It's a duty to distribute and redistribute resources in such a way as to alleviate the suffering of those harmed through no fault of their own. And the same point applies in the present case, I think. So Big Corp in this case has contributed to the causing of the damage to Greta's property to degree 0.6. I think that's a wrong for which paying 60% of Greta's losses is the required remedy. How Greta ought to be compensated for the remainder of her losses in this case is an interesting question, but it's a question of distributive justice and not of corrective justice, and therefore not a question, in my view, to which tort law need to provide an answer. So that's me.
Well done. Okay, yes, stay where you are. Your grilling starts immediately, and I think I'll start it. You said there's one objection to the principle of proportionality. Yes, there are many. The first one, there are two big ones in my view. The second one is you're arguing for Greta's life essentially to be, or was it Greta? Greta's life has been put in the hands of those awfully unobjective humans known as judges. So proportionality, the second objective, the second of major objection is you want to give judges more power.
Well, I didn't specifically say that judges should be the ones who decide the degree of causal contribution, but I guess it's natural to assume that comes within their purview. I have like very few opinions on that, but there is, I guess, a rule of law worry that, you know, there's a nice quote I can't remember who said, I think it's Chapman said, if causation is difficult enough, degrees of causation would really be a nightmare. So the worry is, if, you know, you ask judges to decide on the degree of contribution a defendant made to a causing of a harm with no guidelines as to what that means, then it's going to be very unclear prior to bringing a claim what the outcome of the claim is going to be. So what we need, therefore, is a definition of what it is for an event to contribute to the causing of an effect to degree X, or whatever it is. And I should put my cards on the table here and say that my day job is a PhD student in the philosophy department, so I'm very much an imposter here. So that's sort of the main work of my thesis, is trying to answer that question. And I think it has interesting applications to the law. But in terms of who should be the ones who decide these things, I'm very much open to suggestions on that.
Philosophers, not lawyers, hopefully. Okay, let's go. Who's convinced? Yes.
How you determine whether someone has given a 45% contribution, or a 40% contribution, or a 30% contribution, which is, in terms of effort you put in, a very difficult decision to make, but sometimes it may mean a decision which is worth like thousands and thousands of pounds.
Right, yeah. So the basic idea is that it's based on the probability of the harm occurring conditional on the action occurring. So if you have two people who both commit a negligent act, and those two actions collectively cause a harm, then the question is, who contributed what to the causing of the harm? The basic idea of how you work it out is you take the probability of the harm occurring conditional on this occurring, take the probability of the harm occurring conditional on this occurring, and then you basically take this, divide it by the sum of the two, and that's the degree of contribution that this made. And similarly, you take the conditional probability on this side and divide it by the sum of the two, and that's the contribution that made. So degrees of contribution to causing sum to 1, and then basically it's a function of the probability of the harm occurring conditional on that. So that's the metric, and there's a number of questions you can ask about that. But.
So the criteria is say in the percentage in which the actor could have been foreseen the thing. Is it correct?
Well, so it's not necessarily subjective probability. So maybe like, you know, there are many cases where it's clear cut. So if company A releases 800 tons of toxic substance and company B releases 200 tons of toxic substance, and there's a threshold 1,000 tons above which the fish population will die and below which they'll probably be fine, then that's a case where it's pretty clear cut that company A contributed 80% to the causing of the death of the fish, and company B 20%.
So it is objective or subjective?
They're objective probabilities. It has nothing to do. Obviously, to be at fault, the defendants have to have reasonable foresight and so on, but that doesn't, if they're objective probabilities that go into the calculations of degrees of causal contribution.
But this crashes with the principle that no one can be held liable for something he did not want and foresee.
Yes, so that's why it has to be negligent wrongdoing for you to be held liable in the first place. So
But if it is objective, the principle of negligence disappears.
No, so
it must be
so objective probabilities don't go into the calculation of whether or not it was negligent. So there are different stages of inquiry. First of all, you have to find out whether the wrongdoing was negligent or reckless or intentional, etc. Secondly, you have to figure out whether the wrongdoing was a cause of the harm. Thirdly, I think you need to figure out the contribution that the wrongdoing made to the causing of the harm. So that third stage, I'm arguing, should be introduced. I'm still thinking you should keep the other two stages. But rather than just going fully liable if you're above the threshold of the approximate causation, 0% liability otherwise, I'm saying there should be this third stage that's more discriminating, that says, let's figure out the degree of contribution and let's hold you liable to that degree.
We have to allow group grilling, so let's go.
I'm concerned you have a practical problem, that while this may work in theory, I come from
perennial problem of philosophy.
Well, yeah. No, I come from Philadelphia, in the United States, which is the most attractive plaintiff's jurisdiction in the whole country, because we give the best awards. And I can tell you, in Pennsylvania, you can make your rule, or in Philadelphia, you can make your rule, but the juries won't follow it. And so I think you have a practical problem there, that the law may be one thing, but the juries are still going to say, well, poor Greta got screwed. We're going to give her the 100% from big company A, even if it isn't really their fault. And I wonder, how do you address that where the practical and the theory might not meet?
Right, yeah, so there's problems with both options. Is it down to the jury to decide what the degree of contribution is? Is it down to the judges? I guess it's a difficult technical problem, and so leaving it to the juries might be difficult on that count. But at the same time, it's not a legal question; it's a supposedly factual question. So should it really be the judge that decides that? It's difficult. Yeah, it's difficult. I have no answers. I'm just saying. I'm just sort of throwing it out there as like an interesting moral principle that responsibility can come in degrees, so shouldn't liability come in degrees as well? I mean, one thing you might do is just have a more coarse-grained approach where you have full liability, 50-50 split, zero liability, and then that might be more, easy, rather than allowing. But in cases where damages have to be apportioned, judges have pretty much complete control over how to apportion damages, and there's absolutely no guidelines on how they're supposed to do it. Well, I mean, there's some precedent, but there's a bunch of different factors they have to consider and no guidelines on how to rate them. So if the concern is that judges are going to have to make some difficult factual determinations, they have to do that anyway. So
Judges make things up. Like ordinance.
If it's a moral dilemma, as you say, how far is the policy implications? What you're saying? How far is your solution where you say this is corrective justice sorted out by tort law, distributive justice happens over there? How far is one contingent on the availability of the other? In other words, how far is your proposal defensible based on the fact that the state or whoever else exists? Because tort law is really just about screwing over insurance companies. It's about, there you go, it's your problem now. Isn't that just a great thing? Why would you want to unsettle that?
Yeah, good point. So I guess what I'm doing is sort of ideal theorizing, which is thinking about how things would be in an ideal world. So in an ideal world, you'd have a system that is responsible for distributing resources in the fairest possible way. A system that's responsible for punishing people to the extent that they deserve to be punished. And a system that deals with righting interpersonal wrongs. And they're just completely independent. And they all function perfectly. The problem is that the state is normally responsible for the first two, and then often, for various reasons, aren't able to discharge their duties to distribute resources in the first possible way, or punish people to the extent that it's necessary to be punished. And so tort law is this nice way of picking up some of the slack that's left by the state's failure to address these things. Personally, I think this is, the fact that Greta would be left with no money, or less money in this case, is more of a reason for the state to address its distributive obligations than it is a reason to, mess about with the normative foundations of tort law by trying to get it to do different jobs that it can't perform at the same time. But that's, in the holding fixed the imperfections of the world, it might be permissible, all things considered, to make do with an incoherent tort system that doesn't make any less incoherent.
Excellent. Thank you very much, Alex. I like the way you're all finalising on sort of an almost philosophical point. Very nice. We'll find out if they're convinced later. Don't worry. Okay, we have Seamus Byrne, our third soapbox speaker. You have 5 minutes. Seamus is from the University of Liverpool, and he is asking, should children be allowed to vote? Your time starts.
Okay, thanks, Michelle. So the very first question that I want to ask, or that I want to analyse, is whether children should be allowed to vote. And what I'm arguing is that they should be allowed to vote, and secondly, that the current age limit of 18 years is arbitrary, and it should be removed, and there should be no limits. Why I'm arguing this is, firstly, that I fervently believe that the age limit is arbitrary, it's baseless and uncontained, and it's essentially anti-children. And the reason for that is that the right to vote is an essential human right, and it's often termed as the preservative of all other human rights. Why? Because it is the point of the demarcation between tyranny on the one hand and the democracy on the other hand. So the sole question is, why do we deprive children of the right to vote? And from an analysis of the literature, the core and essential reason is that we view children as dependent, and we also view them as ignorant, and we also view them as essentially not being capable of articulating their own personal viewpoints and their own subjective views. I also argue that this adherence to what I call age-based competencies does not survive any form of rigorous scrutiny. Why? Because it doesn't uphold the fact that children are actually social agents in their own right. And I also say that age-based competencies fails to take into account the cultural aspects wherein children thrive, and also they develop as social agents. Here in the United Kingdom, we have, according to the Children's Society, we have 166,000 young carers who, from the age of 5 years old, they are giving pain, relief and other substances to chronically ill parents and also chronically ill siblings. From a recent study by the BBC and the University of Nottingham, they actually say that the young carers in the United Kingdom are actually 700,000 in number. We also know from Zimbabwe, there's a recent study which actually tells us that children from as young as 10 years of age are expected to build their own houses. And we also know that children from 10 years of age are expected to be farmers. They're expected to be trading in livestock, and they're expected to be partaking in those essential decisions which underpin both the family and the community. From the asparagus farms in Peru, we also know that children from 13 years of age are expected to be making adult, what we conceive as adult decisions in terms of the allocation of the income and so on. We know in Bolivia, for example, children between 13 and 16 years of age are making decisions in relation to whether to stay in school or whether to go out and to work. So the core issue that I'm going to be making is that age-based competence, which is 18 here in the United Kingdom and in the common law world is outdated. It actually fails to contextualise the unique circumstances wherein children actually find themselves. I also say that when we remove the age limit, that the obvious issue is that it's going to present practical problems. How so? If children are able to articulate their personal preferences and they're able to put the X on the ballot box, then we actually should be in favour of that. Any other practice is repugnant to both established children's rights and is repugnant to basic child law principles. Every single child has the basic right to articulate their own personal views. It's enshrined in Article 12 of the Convention on the Rights of the Child. And we also have to be cognizant of the evolving capacities of the child, which is protected in Article 5 of the Convention on the Rights of the Child. The current age limit is arbitrary and it's outdated.
Nice wrap up, Seamus. Thank you very much. Okay, are we convinced again? I'm not. I'll tell you why. If you like children so much, which you seem to do, why do you want to socialise them into this system of corrupt democracy?
The issue of corrupt democracy, the essence here is partaking in the system, and the current system is it actually segregates children. They are denied the right to actually vote. And the core question is, this corrupt system has been established by adults. It has been preserved by adults. So therefore the fundamental question is, therefore it actually would fall to the children to actually remedy this adult-led corrupt system. So therefore the core issue is, we have removed children from the system, and you perceive the system to be corrupt. That actually would tell me that we actually need children in the system for their own personal views to be upheld and articulated and expressed.
What I got from that is, you're not a child.
Wouldn't families with lots of children have lots of political power because they could just tell the children to vote? Like Kelly.
The other issue there is, and to draw on the other end of the spectrum, if you have families with large amounts of adult siblings who inhabit the family home, which is a very prevalent practice within the United Kingdom and indeed right over the Atlantic Isles and Ireland also, then the same argument can also be advanced in relation to those. The core issue here is upholding the personal rights of individual children to express their own political preferences freely and in their own space. And I also think within the judicial system we have child-led, we have child justice guidelines, and they're made children-friendly. And I think that political parties can also put their policies forward in a child-friendly environment also, and in a child-friendly manner. Core issue is, we know from all over the world, children are exercising social agency, economic agency, and political agency. And I think that we should uphold that and respect it.
I'm going according to where I saw hands, so.
Okay, so just in the spirit of being polemical, so your big argument is that it's arbitrary to fix a particular way to vote, children have got different levels of development and stuff like that. But isn't so much of society organized around a series of arbitrary age limits? And so I want to know, would you remove age of consent, age of military service, age of legitimacy to work, age of driving, and base that on children want to have the right to do all of those things too?
It's an interesting which reveals issues which are outside the parameters. But just to articulate briefly on some of those issues, the age of consent firstly. There's vast differences within the age of consent right over the world, from 12 years and to the Holy See, which is 18 years. I didn't know there was many children in the Holy See, but the age was 18 years of age. I think that the issue on a more deeper level, it actually raises fundamental issues both in relation to the autonomy of children and to the social construction of childhood. In relation to all of the issues which you have actually raised, military service being one of them, there's a disconnect between actually joining the army and actually not being able to vote. You can get married, but you still can't vote. Those are practical disconnects which have social upshots in the sense that but I support the autonomy of children, but I would have to revisit the question perhaps in another soapbox forum, but I do this more research.
There were a couple more hands over here. Are they still there? Don? Okay, this gentleman here, then this lady, then this gentleman, then this gentleman.
I mean, obviously, all of these age guides, I mean, they're all artificial constructs, as you pointed out. I mean, they're arbitrary numbers that were decided upon. But there has to be some limitation at some point. I mean, you couldn't, I don't see how an infant practically could go and vote. So how do you create a system? I mean, and you couldn't do it based on literacy because there are plenty of adults who are illiterate, and therefore, you know, you would be depriving them of the right to vote, or the physical ability to put the mark in the box, because then a paralyzed person would then be deprived of the right. So how would you, at some point, the child would have to reach some point where they could begin voting, and how you do that without aid?
You've raised a very interesting issue, and the answer to the question which you have raised, I think, actually lies in the distinction between holding the right and exercising the right. And they're two entirely separate issues. Take, for example, an elderly 80-year-old dementia patient. They are not stripped of the right to actually vote. They might not be in the position to remove themselves from the family home or from a care home and exercise the right to vote, but they retain the right to vote. And therefore the distinction is made between holding the right and retaining that particular right and the subsequent exercising of the right. Of course, a 5-month-old infant is not going to be in the position to go into the ballot box or into the polling booth, go behind the little curtain or whatever, and exercise the right to vote, but they retain the right to vote. And there's a distinction which I think is there. The example which I would actually use is the elderly dementia patient. Just also in relation to that, I think there's an internal assumption there that just because you have the right to vote actually means that you actually will vote. And the general election here in the United Kingdom 2015, the voter turnout was just over 60%. 2001, the voter turnout was actually 54%. So adults don't actually exercise their own right to vote when they're able to actually do so. So the answer to the question, I think, actually lies in the distinction between holding the right and then subsequently, if you so wish, exercising the right to vote. In the same way that you can join a trade union, and in the same way you have the right to actually not join the trade union. Does that make sense?
Your soapbox is becoming stank at this. Oh, okay. There was 2 hands here. Go ahead. Yeah.
Yeah. Okay. One political scientist said democracy is incorporated. So why engage children in this, incorporated democracy that is, determined by money and money only? Democracy, rule by law, is disappearing, and democracy by corporations and powerful states is in the rise. So why engage them in this?
Why engage children in democracy? The answer, I think, to that particular question is the fact that the purpose, well, in the United Kingdom, the same way in my home country, decisions are made at the political level. They are cross-cutting and they interfere in each and everyone's daily personal lives. And some of the decisions which are actually reached at the political level, they're going to interfere with children's lives. So the core question is, how should we be depriving children of the ability to articulate their own views within the democratic process? I think the answer also is connected with the issue of citizenship. In the United Kingdom, from the moment you're born, you attain citizenship. And I think that as a citizen of a particular state, then you should be able to engage with the democratic system and the democratic makeup. I think the other question is the same tired old arguments which once excluded women and the same old cliches which excluded particular sectors of society from the democratic process are being actually used to prohibit children from engaging with the system. I don't see any powerful reason to exclude children from the democratic system. I think it's inclusive and healthy if we do.
There was one other hand somewhere.
Okay.
You're done? Please. Sorry, Byrne. And then you're last. Sorry. Right.
This is slightly different, but what would you think about extending the possibility of this being extended to children running for election? If children can vote, then they're
Children for elections. Well, we have youth councils and we have various sort of sub-statutory bodies where we have children, whether they be in secondary schools or with local councils or so on. The reality with those, they're merely paying lip service. Personally speaking, I would have absolutely no problem with children and with young people actually running for parliament. Absolutely not. I think they would make far more suitable candidates and candidates which stand for extremely powerful offices. If they're technically qualified, then they should be able to run. And if they reach the obvious quota, then they'll be elected. No issue with that.
They were by democracies.
Good. Another good wrap up, I think. Okay, our final. Thank you very much, Brent. Our fourth and final soapboxer is Joshua Hughes from Lancaster University. Joshua is going to speak about killer nerds, the legal problems with the NSA's role in trouble with killing. You have a PowerPoint? Oh, the chapter on PowerPoint. Let's go. Oh yeah.
Okay, so I'm Josh Hughes. I'm going to talk about the NSA, which was made famous by leaks from Edward Snowden. I'm going to talk about mass surveillance. I'm going to talk about their role in target killing and potential negligent failures which could cause civilian deaths. The information I'm using comes from investigative journalism, interviews with drone operators, and leaked documents. So I can't really verify it completely, but I still think it raises potential issues worthy of legal analysis. So what is target killing? It's essentially a manhunt to find suspected terrorists, capture them if possible, and if not, kill them, often using drones. The National Security Agency, or NSA, is America's second biggest intelligence organization and deals with a collection of signals intelligence, or signals. This is acquired by intercepting communications between people, electronics, and machines. It encompasses both the content of some communications and data about them, including time, place, and duration. The NSA is directed by a four-star military officer, currently Admiral Michael S. Rogers, and crucially is staffed mostly by civilians, some in military support roles. The NSA has two roles in target killing. First is providing information on terrorists for the target selection process, which the US National Counterterrorism Center uses to draw up so-called kill lists. The second, more lethal role is tracking targets and feeding their locations to targeting centers which command strike capability, most often drones. So essentially, NSA officers use signals intelligence to pinpoint the location of targets and give that information to drone commanders, who can then carry out missions to kill targets. In order to find locations, the NSA tracks compromised SIM cards, triangulating their position through phone masts, or they track electronic devices in the vicinity of compromised Wi-Fi routers. However, nobody can be sure that compromised devices and phones are with the target. In areas where alleged terrorists often live, mobile phones are regularly sold on, lent to friends and family, or as Al-Qaeda commanders, they're just given to subordinates to carry forward. There are safeguards that should be used to positively identify targets, such as humans looking at the target to visually confirm our identity. But because getting people into these areas is often infeasible, and drone cameras often have poor resolution, visual confirmation is often infeasible. So other types of signals intelligence are used to confirm identities, such as travel plans generated from communications intercept. Thus, issues with signals are not cancelled out, and NSA can be tracking the right phone to the right place, being carried by the wrong person, and that person ending up dead. To me, this raises the possibility of NSA officers being criminally negligent and willing to kill. And Common Article 3 crime advanced violence to life and persons, including murder, there are substantial issues. There are also substantial issues for command responsibility, but that's the presentation. Well, that's the presentation at the time. The criminality by NSA officers found currently, they would be subject to internal investigation, possibly a secret tribunal, and probably resulting in a quiet resignation, which to me is not justice seems to be done. And usually, only intelligence officers publicly outed. Usually, the only intelligence officers publicly outed are those who are traders in leak secrets. I suggest an alternative. Finding intelligence officers in military courts with the NSA constitute the paramilitary. Firstly, we must accept that the US would not allow another state to attract intelligence officers for such actions, bringing the US position that it is in a global, non-international armed conflict with terrorists. It's our starting point. With a military trial, criminality can be tried publicly with redactions for national security concerns. Whilst a civilian trial could also have redactions, the reconstitutions of paramilitary avoids NSA officers sharing combatant status with terrorists, i.e. that of civilians directly participating in hostilities, which the US would want to avoid. It also gives intelligence officers combat immunity and protections, but makes them subject to lower armed conflicts and a military discipline structure, which is more appropriate to conflict scenarios than domestic or human rights law. Assuming the US courts would apply international criminal law standards for gross negligence to be shown, NSA officers have to disregard the standards required of them under the law of armed conflict, i.e. to distinguish civilians from combatants and take constant care to avoid civilian casualties. They cannot uphold these standards if only using signals intelligence to provide targeting information. Second, they must be aware of the civilian casualty risk, but believe it will not happen. Assuming NSA officers are aware they are tracking devices, not people, yet still pass on the locations, in the belief that legitimate targets will be killed and not civilians, I think they would be grossly negligent if civilians would subsequently die. So, to conclude, the NSA tracks devices, not people. This leads to targeting issues of potential criminal negligence. The current accountability regime offers neither transparency nor real justice. I believe my alternative offers greater transparency and greater potential for justice, while taking into account the realities of risk policy and legal decisions.
Ooh, juicy. Excellent. Thank you, Dr. And within the time. Okay, as ever, I have an unconvinced question. Is that a proper phrase? I have a question. Okay, we want to cast the NSA as a paramilitary. Have I understood correctly? Because yes, the United States Army is so good at adhering to international law generally.
Well, I think we're better to have it as a paramilitary rather than an intelligence agency cloaked with covert action, because then you have nothing that can come out of it. If it's a paramilitary, it has the potential for some things to come out more potential for transparency and justice.
Believe in the law.
I'll give it a go.
Let's go.
Yeah, if there's nothing, if they're tracking devices enough, they're actually not violating human rights or humanitarian law because they're only targeting and destroying devices, which is not
But it's with the intent to just kill the person who's carrying it. So, it's with the intent to kill the person. That's a good point. But, so the NSA are giving the location of the device with the intent to kill. The drone commanders have the intent to kill the person carrying it. So I think that's
Thank you. Really?
But they from their accounts, they were acknowledged that they don't know who has the device. And you have to quote that they're tracking devices.
So I think that
Well, it's kind of a link thing. I mean, I think the problem is that where the argument goes and kind of see is if you cast them in this way, then you can get them on the not distinguishing between screens. But all they'll say is it's a proportionality issue, it's not a distinction issue. Like with using a bomb, it's in some civilians, but we think that is a proportionality thing. And once you go down the proportionality rabbit hole, the legal basis of trying to get disproportionality is not great. It's not a very strong basis of transparency.
I think the more distinction because it's the intention to kill the person with the bomb rather than the proportionality around the civilians who make it kill to collateral damage. So I would go with distinction.
May I step back in for a second? Is it that being a paramilitary organization gives a new mindset, or if you're in a military organisation and adhering to a job, then you become sort of more minded to avoid civilians, for example, or take responsibility. Or is it for the NSA themselves, or is it for the civilians? That would be cool.
I think it's both. Because if the NSA has to abide by rules more appropriate to the scenario, it protects, offers more protection to civilians, but it also makes them act in a way, with more, which could protect civilians.
Would you be worried that it would legitimise the practice, bringing it more clearly into mechanisms of accountability? And would that be an effect you would be content to see?
I don't think it would necessarily legitimise the practice, because I think it would increase accountability, making the practice, putting under greater focus for responsibility. So I don't think it would necessarily legitimise it. I think it would more like to reduce it, or at least have tracking the phones to part of targeting rather than an essential, rather than the crux of the matter.
But if the accountability is superficial, is it strategically better to have it sitting outside the frameworks of international law in some senses, rather than trying to incorporate it and sort of smooth over the edges and give them the opportunity to justify a proportionality test?
So you mean is it better to have this covert action so you can kill lots of people?
No, quite the opposite. And so you can criticise it as covert action, which is just murdering a lot of people. And by bringing it within legal mechanisms, sort of creating a false sense of accountability when realistically they've probably been able to avoid all these tests along the lines that Rob suggested, then does it have a more detrimental effect overall?
I would think that the fact that there's a possibility of more accountability and responsibility in trials, and I think that's far better than having a quiet resignation and going away to the city to do cybersecurity and $10 million a year.
Rob?
Just to actually to build on Mike's point, like I think one of the big problems with what you're proposing is that it accepts as legitimate the whole framework of the war on terror. So you're saying like, oh, there's some kill lists, and the problem is they're not killing the right people that are on the kill list. But isn't one of the really big problems what we actually want to focus accountability on about the construction of this list, who gets on it, how they place on it? By talking about the mechanisms that you're talking about, you're placing all of the attention on what is ultimately the product of a much bigger and worse system.
Thanks for that point. But I think any accountability really for actions within the whole targeting program is got to be dealt with by the US in their way. And I think this offers a better alternative than what is currently.
Yeah.
Would anyone still want to apply as an NSA intelligence officer?
Sorry?
Would anyone still want to apply to work as an NSA intelligence officer?
People apply to the CIA Sexual Activities Division, which is also paramilitary, so I don't see why not.
Does that encourage the right mindset or the right people to join the NSA as per its purposes?
Well, it's still doing the same job. So I don't see why it would change, other than
Big nerds.
Although the fact that it's a paramilitary doesn't require any extra physical exercise. There are, of course, army nerds as well.
It's true.
So,
I'm certain there are more friends who feel on this one. I'm going to do that thing. Go on, Ben.
Yeah, it's accountability not just a much broader concept than like why are we only talking about the individual accountability of the one guy who pressed the button or whatever? And is he or she actually the person that we actually should be looking for? So it's similar to obviously accountability expression not much higher, but also it's a lot of command, chain of command which also we concentrate on as well.
yeah, in terms of chain of command, I alluded to it, but I had hoped to include it, but it's fine. So I mean, obviously, the reality this shouldn't even happen because the commander should realise it's faulty intelligence and should rectify it. But according to police reports, it does happen anyway. So then that leads to accountability for the commander as well. But in terms of the whole sort of system being accountable, the chap called Gregory McNeil, who wrote a really long article titled Accountability, sort of says the code of public opinion is another form of accountability, like other professional accountability and stuff like that. So that is part of the whole accountability whole system. So we're happy with that.
Yeah, I probably would be, because I think, yeah, there's also some towards to accountability. I think maybe cloaking the individual as parallel, you might see the paper as a stronger form of accountability, but I don't know whether it's slightly artificial. And maybe this idea of this public accountability maybe your issue is the fact that they get to know somewhere else. Maybe you get these artists called up paranoid, or you just walking down the street and make sure everyone knows what their name is or something like that.
But then just put them in the same bracket as traders, but whether you prefer to do that.
Final burning question, thank you, Fred.
Are there other organisations that should be reframed so that we can reprimand those organisations in a transient and publicly acceptable way? Because so this seems to be reframing the way that the NSA is seen by the law, so that we can criticise it or deal with it in a way that is impossible at the moment. Are there other organisations that should have that happen to, because we don't like what they do, but we can't quite criticise them as we would like to?
I guess you could say the United Nations Security Council. But I don't know really. I guess you could say other intelligence agencies who do shady things, but it's an interesting point.
Excellent. Thank you, Joshua. I can't figure out if this would make it very popular or very unpopular if it was not read in the New York Times. I'm not sure. Very good. That's our 4 soapboxes. All 4 were, I think, you'll all agree, super, really interesting. This is the most fun I've had for ages, which is really embarrassing. Patrick, a question: do we get to vote on whether or not we're convinced as an audience, or does that mean?
Yeah, you can.
Vote. Okay. Ben Murphy argues that United Nations Security Council is unbound by law. Hands up if you agree. You were convinced by Ben.
We had more than one vote.
Yes. What do you mean? We all get to be convinced by all or not. Yeah.
And my children vote.
I don't know. You only have one. Okay, I'd say that the majority are in favor. Is anyone against? Is anyone not convinced? Okay, good. Alex, partial liability. Do we agree with Alex that we need a sliding scale rather than an all or nothing? Are we convinced? Oh, you've had a much more mixed reaction, haven't you? Not convinced by the philosopher. Lawyers are never convinced by philosophers. Seamus, Byrne, should children have the right to vote? Yes, he thinks they should. Are we convinced? That's a proper split. Interesting. Children haters. Joshua Hughes, the NSA should be recast as a paramilitary. Yeah, you haven't convinced too many of us. Excellent. Thank you all 4 of you, Seamus, Joshua, Alex, and Ben, for your soapbox presentations. That's not an easy thing to do, and it was really enjoyable. Thank you very much.
Oh yeah, take just a minutes before we head off to have our evening reception. First of all, I'd just like to thank everyone on behalf of the Organising Committee, myself, Bianca, and Byrne, everyone for coming and giving some really interesting presentations. So I'd like to all give yourselves a round of applause. And then I think just before we leave, I'll hand it over to Amandine Cardi, who's
everyone. I also had a lot of fun. I unfortunately attended only the last 20 minutes of this event. I really couldn't come more. And I've already taken a lot, so my next conference will be the Soapbox. I'm not sure we'll be voting, but we will certainly have this format. I think from what I've heard and what I've gathered throughout the day, this has been a really successful event, not least because of the variety of presenters, the variety of papers and themes that have been discussed, and also the various formats. And I think, like my colleague, having participated in a range of events and organized a range of events, the key element to a successful event is probably a variety of format, from a standard paper to this soapbox to roundtables and so on and so forth. So I won't hold you long, but I'd like to extend a very belated welcome to you all to Liverpool Law School. We are known and we pride ourselves on our collegiality, so I hope you've got a sense of this collegiality throughout the day, and you will enjoy the reception tonight. We integrate our PGR students to all our activities. We rely heavily on them, and we're grateful to them for our teaching, our research projects, the activities of our centers. But here, the credit is due entirely to our PGR students. They initiated this event, they raised money for this event, they drafted the program, they organized it all. So we just, by participating here today, get the benefit and the pleasure of contributing to the discussion, but we haven't had much of any of the burden. So congratulations to the organizing committee in the first place, Bianca, Yvonne and Patrick, whom you will have met. We are very grateful to them for this successful initiative, which once again they had themselves. We are also grateful to all the PGR community at Liverpool, a very vibrant, growing community, and a lot of students and researchers have been here today, so thank you to you too. And of course to all of you for coming to Liverpool and making this event the success it has been. A great thank you as well to our colleagues who have helped in various ways and have challenged the participants. Michelle, I've seen the last 20 minutes, Rob, Mike, and many others. So thank you for being collegiate as you always are. And thank you to our sponsors, Hard Publishing and Thomas Reuters, for helping with this event, the buffet, and all the activities that have required funding. So a warm welcome to you all. Unfortunately, it's raining, but somehow you may be aware of the bucket list of a rough guide, which says that between the wall of Petra in Jordan, the wall of China and Petra, the city of Petra in Jordan, is Liverpool nightlife. So I very much hope that you have some time to make the most of what the city has to offer. Having visited the university, even though I've passed the age, I regret to say, and therefore I haven't had as much fun as today as Michelle has too. I'm told this is something really people should go and enjoy. So please make the most of your stay with us, and don't forget we offer jobs on a very regular basis. We're an expanding law school, so if you had a good time here, then send us your CV when we next advertise on Jobs AC UK. We'll be glad to have a look at it. Very warm welcome and have a good evening.